Her mugshot has gone viral, and the story behind it is so dark, disgusting, and disturbing. But it is a story that every parent should hear. We are following a story of a babysitter who is accused of the unthinkable. This woman not only allegedly sexually assaulted a child, but prosecutors say she filmed it on her phone. And just wait until I tell you how police allegedly found out and what else this babysitter is accused of having on her phone. We're on the case presented by Law&Crime. I'm Chris Stewart. If you're a parent and you hire a babysitter, it might just be a neighborhood kid looking to pick up some extra money on the side, but it is a major responsibility. And we probably forget about that sometimes when you think of a babysitter. I mean, you're leaving your child in the care of someone else. But what a babysitter in New Jersey is accused of, it goes beyond, I think, what anyone could imagine. And that babysitter is the woman you see here, Victoria Cranmer. She is 25 years old, and she is currently in a jail in New Jersey, and she's being held without bail, and we'll talk about why in just a moment. Cranmer, from what we can tell, she's very active on social media, and she's not afraid to lay out the issues that she claims she was having in her life. And that includes issues she says are related from a traumatic childhood, it seems. Found a post on TikTok where she writes about how her dad died when she was 13 on Christmas. She says she was taken away from her parents when she was 11, that she had to move 36 times as a kid, and she was in therapy by the age of 10. It is unclear kind of the details behind that childhood, and I am bringing that part up not to, and I want to be clear on this, create any kind of sympathy for this suspect. It'd be hard to find sympathy based on what she is accused of. But I did want to add some context as to who we're talking about in this story. So this all takes place in Ocean County, New Jersey, South Jersey, kind of closer to Philly than New York, north of Atlantic City. And here is what we know about a very sick and twisted case and how it began, according to court records. So I want to go back to May 20th. That's when all of this starts. And that's when the New Jersey Division of Child Protection and Permanency contacted police in Little Egg Harbor, New Jersey. So that group investigates concerns about child abuse and neglect in New Jersey. And this case began because a woman who's identified in court records as Miss H said she had concerns about her son and Cranmer. This is according to a probable cause affidavit that was acquired by Jersey Shore Online. So that child is believed to be under the age of 13, but older than the age of 4. So in these court records, Miss H said that Cranmer was the babysitter for her son. And she said she was no longer the babysitter because of what she allegedly had uncovered about what was going on between Cranmer and her son. And she says that she found out about some of these issues because of the way her son was acting, but also because of another mom that had reached out to her. So this is a woman who's identified as Miss P in court records, and this mom was a friend of Cranmer, and Cranmer had actually been staying with that mom for 3 months. And that mom, Miss P, according to court records, has a daughter who Cranmer also babysat for. So Miss P said that Cranmer had mental health issues and that for a birthday present for Cranmer, she bought her a cell phone. And that cell phone is critical to this case going forward. Now, Cranmer's mental health issues, we don't know what the history is related to that. It does not appear that she has a criminal record, but those mental health issues, according to these court records, they were becoming such an issue at home that Miss P told Cranmer to get out. But she needed to leave that phone behind. And this is where this story goes to an entirely new and terrible level. Documents alleged that Miss P searches the phone once Cranmer left it behind, and she made just the kind of discovery that will never leave you, and just the kind of discovery that would make your heart sink through the floor. Allegedly, she found a 14-second video that was saved on Cranmer's Snapchat profile, and it was in the memories section. So that video allegedly shows Cranmer sexually abusing a child in the bathroom of the home where she was babysitting. This next part's really sick. Authorities say she was allegedly laughing in that video as she committed the abuse. Now, police say that video was shot all the way back on May 6th. Now, for as awful as that part of the story is, Sadly, in some ways, it was just the beginning. Investigators say they later searched the entire phone as well as Cranmer's Snapchat account, and they say they uncovered additional videos in the memories feature of Snapchat. It is unclear at this point what those videos show, but they have been named in court records, which certainly raises some concerns. Now, roughly 2 months after that first video showing Cranmer sexually abusing the young child was taken, according to police, charges were filed on July 7th. Here's Cranmer's mugshot. She is currently in the Ocean County, New Jersey jail, and according to those court records, she is being held on no bail at the moment, and she faces 4 charges. One of them is listed as sexual assault of a victim older than 4 years old. She's reportedly also charged with second-degree manufacturing of child sexual abuse material, third-degree endangering the welfare of a child, and third-degree possession of child sexual abuse material. Now, it is unclear at this point, again, what those other videos show that police say they found on Cranmer's phone and on her Snapchat profile. And it's also unclear if police believe there are more alleged victims of this woman, and it's also unclear if more charges could be coming in this case. Now, online court records, they do not show a date of when Cranmer is next due in court. Joining us now to talk more about this case is practice professor of law at Temple University and a former sex crimes prosecutor, Marian Bracha. Thanks for being here, as always, on Law and Crime. Really, really disturbing case here. What do you make of the timeline of how long it took to get to the point where there were charges? I mean, this was something that law enforcement, it seems, first learned about back on May 20th.
So I don't think that the timeline is particularly remarkable or really egregious in this case. I think any time an investigative body takes the time it needs to do a thorough investigation, to do what's colloquially referred to as a cell phone dump, to do the forensic analysis they need to do of cell phone contents or video contents and the native files that are attached to the evidence that may be produced from those devices, I think is a good thing. So I don't interpret this lag time, as it were, between the information being provided or allegations having been made and the complaint issued or the warrant issued in this case. I think it likely was the time that the police needed to do their investigation and get the reliable evidence that they needed to substantiate the warrant application.
And now that she's been charged, she's being held, from what we can see, without bail. And then there are these concerns about other videos that were allegedly found, like, on her phone. She is facing charges right now, but as far as, I guess, the timeline going forward on a case like this, like, how does a prosecutor handle that, knowing that potentially there may be more charges? This case could go in an entirely new direction, just depending on what could be found down the road.
It could, and I think that the prosecutor would have to make a decision based on those any potential additional charges, if there were additional charges or additional complaints that came down the line, whether or not they would be joined, and there would have to be a motion before a pretrial judge as to whether or not those different complaints would be tried together. Of course, I would anticipate there would be a motion from the defense or an objection from the defense to join those matters, because there is a perception, right, of the fact finder, especially if this went to a jury, that the more and more incidents that there are, if there is a volume or if there is a number of different occurrences, there might be this human inclination to say, well, gee, one time maybe they got it wrong, but with this volume of cases or volume of complaints, this defendant must have done something wrong. And so there would be, as I said, I anticipate an objection from the defense to join any subsequent complaints, but that would be something that would be dealt with a judge pre-trial as to how the additional complaints would be handled.
And it seems like this case, I mean, at least at this point, from an evidence standpoint, stands around this 14-second video that police say that they found in her Snapchat memories section, and it shows the sexual abuse of a child that she was babysitting for. They allege that she was laughing during it, and I just think if this were to go to trial, I guess what more evidence might you need if you're a prosecutor, if you can just press play on that and show the jury something as horrific as what's been described?
Right. So having video evidence is a very strong evidentiary tool for the prosecutor. Having video evidence is strong for either side, frankly, depending on what the video shows. I think that there are certain evidentiary hurdles that still have to be met when presenting any kind of video evidence or electronically stored evidence or digital evidence. There are still steps that have to be taken to show that the video itself is authentic, that it is what it purports to be, or that there was no doctoring done to it, there was no tampering with the video, or even in this age of AI, that
Right.
no one created a deep fake, so to speak, that is purporting to show the defendant when this is not a real video or an authentic video. So just because we have, and I'm not undermining the validity or the reliability of the evidence that does exist, but in a court of law, just because there is a video doesn't mean that the fact finder gets to see it and automatically the case is made. There is still that evidentiary hurdle of proving that the video itself is reliable, and that it comes from a reliable source or process as a result of the downloading or the dumping or the forensic analysis that recovered the video and made it available for viewing in court.
Well, and I wonder too, like with that, I mean, obviously AI, is different today than maybe like 5 years ago. I mean,
Or
the
5 months
idea
ago.
100%. And like, I think like 5 years ago, like if you had told me, like, I mean, any of these, like the lowbrow stuff that you see on social media would have blown my mind, where now you can clearly look and say, hey, that's AI, like it's moving that quickly. Like, how has the legal system kind of handled that, knowing, I mean, we see CSAM cases all the time. How has that hurdle changed? Like as a prosecutor, like how do you prove to a court that this is something where, I mean, even for a defense attorney to be able to like raise the question of whether or not that's real?
Right. Well, unfortunately, this comes to the point where the courts have to keep up with technology and not the other way around. And so there are movements, there are amendments that are underway in certain jurisdictions to add rules of evidence or to amend existing rules of evidence, to envision the use of AI or any kind of generative source that would create evidence to be presented in court. In this case, if the video were to be challenged as inauthentic or even as possibly the creation of AI or some other kind of digital productive means, the prosecutor may have to call the 14-year-old, might have to call the named complainant or the referenced complainant from the complaint to have them testify, because as much as we like to rely on, I'll call it scientific evidence or forensic data like videos or photos or surveillance or poll cam footage, sometimes the most reliable source of evidence is a human being, is someone who could testify about their personal experiences. As much as a prosecutor would want to spare a child that experience, as traumatic as it can be or re-traumatic as it can be for a survivor of sexual abuse to have to talk about it in open court in front of a jury box full of strangers, sometimes that is the best corroboration for a video that may be challenged on the grounds of authenticity in this age of AI we're in.
Yeah, and I think too, just what does the defense look like in a case like this when prosecutors seem very confident in the video evidence that they have? It does seem, just from reading through the reports, that there were some sort of mental health issues which have not been fully disclosed as of yet, involving the suspect in this case. I know in social media she talked about having like a traumatic childhood. In these cases where something is as horrific as this, like how can that be something the defense can use? I mean, I just imagine, like, I find it hard to find sympathy for someone who's accused of something like this, and yet that is something that potentially the defense could have.
So I think the defendant's history of mental disease or mental illness or mental health concerns might be relevant, but might not be relevant until sentencing. If the case got to that point, it might be grounds for mitigation. It might be grounds for special consideration for some kind of trauma treatment or counseling made a condition of sentence or a necessary component of a sentence. If the defense wants to reference a mental health history or a mental health status as part of the defense, then they're talking about a defendant who was not capable of forming an intent, a defendant who was not aware of what their actions were, essentially someone who was not acting voluntarily, knowingly, or intentionally, which are components of the crime that are charged. And so that would be something along the lines of a guilty but mentally ill defense.
I just think generally as well, because she's facing these child sex abuse material charges. So you have, she's accused of the abuse, but then you have a CSAM charge on top of that. And just kind of generally speaking, like beyond the AI part of it, I feel like a lot of those cases you don't see actually go to trial because it seems very strong evidence for the prosecution. But like, what is a defense there? That someone, I mean, this was something that was in her, and I don't have Snapchat personally, but like, in the memories feature, like she had the intent of saving this video as
Yeah.
well. Like, how does a defense attorney, if you even get to that point, be able to argue that away?
So there is the possibility that the video was pure, I don't want to say purely, but merely possessed and not one that the defendant herself produced or created. And we're not talking about completely eviscerating all charges. We'd be talking about chipping away at the charges that do exist in that are present on the existing complaint. And so while the possession charge might still apply, maybe the defense would make an argument to say, well, this person had a very disturbing video on their phone and in fact did save it on their phone, but she's not the one who created it, or she's not the one who was actually engaging in the conduct and with the complainant, with the underage person on the screen. Again, that starts to chip away at the charges. It doesn't immediately mean that the slate is wiped clean and that none of the charges would remain.
And when it comes to kind of before this would even go to trial, like what are those negotiations like? Like how soon, and this is very recent that she's been, just this month she started facing these charges, but like when does that begin? If there's any sort of idea of any sort of plea agreement that could go in place, especially knowing that potentially there's some video evidence that could mean years in prison already for her.
So I think that the defense shouldn't engage in any kind of negotiations until discovery is complete, until all of the investigative paperwork and all of the forensic evidence when it comes to the cell phone analysis, the actual footage, the actual phone, making that actual device available to the defense for them to conduct their own independent analysis with an independent forensic analyst. I don't think any conversations or any negotiations for any kind of plea agreement would happen or should happen until the defense has a full opportunity to receive the discovery, to review it, of course, and to do the analysis themselves. And then after that, perhaps there would be pre-trial, again, as we mentioned, mental health evaluations and some kind of pre-trial assessment of the defendant to see what her capability is in terms of her mental competency to stand trial to begin with. And at that point, I think the negotiations might commence if there are negotiations, if the prosecution is open to negotiating the case.
Who makes the first call in some of these cases? And does that, I mean, I think in like a business sense, sometimes whoever makes the first call matters. I mean, very different and far more serious situation here. Like, does that matter at all in the negotiation between both sides of like the person who reaches out looking for some sort of deal, whether it's the prosecution or the defense?
To be honest, I don't think it does. And I think it varies, obviously, case by case. Everything varies case by case. But, remember, there are rules of evidence that also protect the defendant from engaging, from having the evidence of her engagement in plea negotiations admitted against her. So it's not like she would engage in conversations with the prosecutor and say, I'm willing to plead guilty to this charge, but not that charge. And then all of a sudden, a fact finder would hear that she had been willing to plead guilty to a particular charge. So she is protected from admission, from the admissibility of the fact that she was willing to engage in the negotiation to begin with. So I don't think it matters too much from a strength of negotiation perspective. I think there is always the priority of protecting the victim from further trauma and further exploitation. And I think there is always the concern about system utilization and judicial economy, and is the right and the just result to have this case tried before a jury and to have this video played in open court, or is the right and just thing to do to dispose of this with a non-trial disposition? And that's something that both sides would have to engage in good faith.
Because I also just think of, for this child, this alleged victim, in this case, like, how do you prepare, to have to relive some horrific trauma on the stand? Obviously, you have to face to the person who's being accused, all of that. Like how soon do you begin that type of preparation? I feel like in the movies, and I hate making a movie reference, it seems like the night before, and then like they're in the courtroom and like that's it, that's all you see. But like what actually goes into preparing victims to take the stand in cases that are as difficult as these?
Well, I think a lot of trust building has to happen, and I think that as soon as a complaint is filed, as soon as a complaint is brought to the prosecutor, maybe even before the complaint is filed or brought, the prosecutor should be in touch with the complainant and their family to explain the process, to check in on them, to see what their status is, what their well-being is, and this is where certain stakeholders in the court system, like social workers, like case managers, like victim witness advocates, are worth their weight in gold, because they are really the ones who are there in such a supportive capacity, maybe not necessarily in a legal advisory capacity, but they are truly the heroes who hold the hands of victims and witnesses, both figuratively and sometimes literally, to get them through what can be a very trying and potentially re-traumatizing process.
No, absolutely. And then just lastly, this time it's Snapchat, which we do unfortunately hear about a lot in these cases, but there are a lot of different social media platforms in these cases. What's it like as a prosecutor? And maybe this is more for the investigators on the case, but like, what does the information actually look like that you get back when you request, as much information as you can get from someone's Snapchat profile?
So it, again, as you referenced, it varies by platform, and with each new platform comes a new set of challenges in terms of how to submit a subpoena, how to freeze the account, how to make sure that there is an accurate snapshot, so to speak, of the data that existed at a particular time or on a particular account. Sometimes what happens is a series of images, or essentially screenshots from a particular platform under a particular username or account. Sometimes it means that all of the metadata in terms of the IP addresses and the usernames and even the contents of communications are provided. But really, it depends on the platform, and it depends on the scope, the four corners of the warrant affidavit that is issued, or the subpoena that would be issued to that service, to that particular social media service or platform, and what they are able to gather and what they are able to turn over to the investigators.
Yeah, just an incredibly disturbing case out of New Jersey, very much in the beginning of an investigation, as well as they're trying to figure out what happened here. Marian Bracha, former sex crimes prosecutor, practice professor of law at Temple University. Always great to have you here at Law and Crime. Thanks for being with us.
Thank you so much, Chris. Nice to see you.
Again, online court records do not show the next date when Cranmer is expected to be in court, but we're going to continue to follow this story. We will keep you posted if more charges are filed or more information comes to light. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify, and we're also streaming on Peacock. I'm Chris Stewart. We'll see you next time.